up and then we'll do that. Okay, now we're now recording. Douglas, can we hear the gambling report?
Yes, absolutely, convener. Sorry, I think I can be fairly brief in relation to this item. I don't really think there's much to add to the terms of the report itself. The gambling statement of principles is something that the board has to review every 3 years, and come the end of January 2022, we're required to have a new gambling statement of policy in place. That involves a statutory time limit, sorry, a statutory timetable, which means is basically agreeing before the end of this year a final statement of gambling policy and publishing it for 4 weeks before it comes into force at the end of January. And prior to that, we have to undergo a consultation. The draft gambling report has been updated insofar as we've approached relevant council services to update some of the kind of information in it, and any necessary tweaks have been made. But obviously the style draft report does have sections in it that were required to be updated further based on the consultation responses, and indeed according to the consultation responses we get, it may be that there'll be further changes required as well. So I don't really have anything further to add about it, other than the fact that I'll happily take any questions about it.
Okay, colleagues, have any questions? Been no intimation of any questions. Can we agree the report? It's agreed unanimously. We'll invite everyone back in and we'll return to the Northern Way.
No worries.
If I could just be advised when everyone is back in. Thank you.
Waiting for Miss Howie and the police. Oh, police are in now. We're just going to phone Miss Howie. That's everyone back in.
Many thanks, Aileen. Thank you for your patience, ladies and gentlemen. We're ready to move to determination in this application. Just prior to doing that, I wanted to say a few words on the nature of speculation, which was raised quite heatedly in our consideration of this matter and the licensing objectives. All 5 licensing objectives are essentially reactive, and it is not legal to impose them on what might happen in the future, which I believe was the point Mr McGowan was making in terms of speculation. And for which he was called a rather unpleasant name, which I was most unhappy about. It's not fair to call people liars when they're actually quoting soliciting law. Mr McGowan's a very experienced practicing solicitor, he knows what he's talking about. The licensing objectives can be applied when things have happened. They can't be applied to what might happen. That is the essential point. I just wanted to explain that before moving to a determination. We now move on to that determination, and we had an excellent discussion of everybody's points of view put forward here. I am going to propose a motion to refuse the application based on the unsuitability of the premises for the sale of alcohol and promotion, in accordance with the proposed variation. Are members agreed?
Agreed.
That's agreed unanimously. Thank you. Douglas?
Just to confirm that the application for major variation has been refused unanimously, based on, as the convener has indicated, that the board has considered the premise to be unsuitable for use for the sale of alcohol in accordance with the proposed variation. And that concludes this item for today.
Any thanks, so?
Convener, just with your indulgence, just before you move on to the next item, I do need to request a direction in this matter. You know what I mean by that, Convener. Certainly Mr. Campbell will, so I would like to formally request a direction, please.
Yeah, basically, the legislation, Convener, precludes someone from making another application within 12 months. However, the board is entitled at the point in terms of section 25(3), I think it is, of the Act, to basically allow another application to be brought within a year. So basically 25(3) basically says that the bar on applying within 1 year does not apply to a subsequent application if at the time of the earlier refusal the board directed that the subsection would not apply, or the board is satisfied there's been a material change of circumstances. So effectively what Mr. McGowan is asking for is the board to basically not close the door on him making another application within the next 12 months. I think that sums up what you're saying, Mr. McGowan, doesn't it?
Yes, that's essentially it. I'm in your honour's hands on this. It's a procedural point under the Act. If you grant me this, it means that I'm allowed to reapply for the licence for the outdoor area on the basis that my clients may choose to seek a reapplication in some form or other. If you don't grant me this, then the Act would prevent my clients from reapplying for 1 year. I think with the balance of convenience, it is appropriate to allow my clients the opportunity to lodge another application and for your honours to consider that on its own merits.
Okay, I don't mind discussing this. Douglas, can I get direction on whether we go in private recess or whether we discuss this in open forum?
We can do that either or, Convener.
Well,
I'm very happy to do it in private recess.
We'll take a recess and get advice. Thank you.
Again, if all parties, not councillors or officers, please leave the meeting.